Okay, thank you very much for tuning in. All right, so basically, she weaseled her way out of this one. And how did she do it? All right, so this is the Civilian Review and Complaints Commission for the RCMP. So, very noteworthy is the fact that this is not, addressing any kind of merit. They're just addressing the dismissal, right? Again, the same kind of idea as the College of, Physicians and Surgeons of Nova Scotia. If you want to check that video, a very, very appalling decision by the surgeons, College and Surgeons of Nova Scotia, that basically, because I'm the father of the deceased child, I don't have a right to complain. But this is a little bit less clear. It's a little bit less clear. This is basically just a rubber stamping on the dismissal. I just give you the file number here, but I redacted my. It's not even my address. I used to live there, but it's not my address anyway. I just redacted that. So the commission has reviewed your public complaint for the 20th of December 2025. After careful consideration, the commission is exercising its power to refuse your complaint under this section here, which allows the commission to refuse a complaint where it finds the complaint is trivial, frivolous, and vexation, or made in bad faith. So none of these actually apply. So it's not a trivial. It's certainly true. It's not a frivolous complaint. I mean, it's certainly not. It's not vexatious. I don't actually believe that it could be vexatious, or made in bad faith. And they don't actually provide which one it is. But anyway, let's see what they said. It indicated that the spouse at the time was administered a noxious substance by the doctor without informed consent, which is true, which allegedly resulted in the early death of your unborn developing child. You indicate that the death of the child is tragic and tangible. Absolutely. The criminality of the act lies squarely on the non-consensual administration of a noxious substance. You further indicate that you interacted with Corporal Vincent Lacroix, who is the Matagan supervisor, the detachment supervisor on the matter in December 2025, and alleged that he incorrectly interpreted the evidence of this alleged crime and failed to properly investigate, and that's true. While the commission is sympathetic to your concerns and acknowledges the seriousness of which you view the allegations, it must be noted that Corporal Vincent Lacroix reviewed the allegations which you submitted and sought clarifications from the individuals named. It was indicated that, based on the information provided by your former spouse, the allegations were determined to be unfounded. Furthermore, your former spouse made it clear that she did not wish to be further involved in these matters. I didn't try to put her in these matters. For this reason, and the fact that Corporal Lacroix advised that you did not provide a clear, substantiated evidence nor a proper statement required for a formal investigation. I did. I sent a whole bunch of text. I'm not in the province because of that. This is one of the main reasons that I'm not in the province. I shouldn't be expected to show up there. What are they going to do? Still dismiss me if I go there? Corporal Lacroix confirmed that the allegations cannot be substantiated and that your file will be closed. It is also noted that Corporal Lacroix informed you that attending in person to provide an audio recorded statement is the standard procedures for matters like this, and should you wish to pursue this matter, you will need to arrange to appear in person and provide a recorded statement so that your concerns may be properly documented and assessed. We have the internet, so there's no need for me to go there and to have my case not taken seriously. For these reasons, on its face, your complaint is devoid of substance and has no reasonable chance of success via the public complaint process, due to the absence of any apparent misconduct on the part of Corporal Lacroix. So, considering the fact that the primary person involved, which is me, it's not the deceived woman. I mean, this is clear. But they continue to do this thing, right? They continue to jump back on the deceived woman. So because of Dr. Michel Dow's successful deception, she's the primary person. That's nonsense. Considering the fact that the primary person involved did not wish to proceed, the fact that the requested substantiated evidence and proper statement was not provided, and the fact that you were given the option of attending to the detachment to provide a proper statement. As such, this complaint is being refused. That being said, although a public complaint on this matter has not been accepted, a copy of your complaint will be sent to the RCMP for whatever action deemed necessary outside of the public complaints process. Right. All right. So there's no further appeal, and yeah. So basically, that's the way it is. You may wish to obtain independent legal advice, and then yeah, that's basically it. Or is it? Well, first and foremost, the science is clear. The pharmacological mechanism of action of hormonal birth control is well documented, widely acknowledged in medical literature, and not a matter of speculation or belief. These substances are designed not only to suppress ovulation, which it does, but also to alter the uterine lining in such a way that if should fertilization occur, implantation is prevented. What does that mean? When implantation is prevented after fertilization, the newly formed human organism necessarily dies. Necessarily dies. And you cannot attach somewhere else. It's not gonna, attach to another place. Right, this is the only place. So this word necessarily dies. I guess I never really, stressed this fact before. Right, so it alters the uterine lining, right? So we see that, okay, alters the uterine lining. Well, what does that mean? I don't really understand. Well, this is clear, right? The newly formed human organism necessarily dies. This causal chain is biological, predictable, and undeniable. Where a human life exists and is foreseeably destroyed through an intentional pharmacological intervention, the underlying act possesses inherent criminal character, regardless of whether a particular legal system has chosen to excuse it or legalize it. Right. So that's what we see here. The legal system here is clear. This is clearly an injustice, right? I'm not, it's like, the thing, gaslighting. I don't really choose to use that word very much, but they're like, no, this guy's crazy. Of course, it didn't happen. It didn't happen because the deceived woman does not complain, right? If the deceived woman does not complain, then it never happened, right? It's like gaslighting or whatever. Gaslighting is it's a term used by the newer generation to say like they're trying to make me crazy, but we see, right, from the pharmacological insert, right, the FDA's own documentation that the uterine lining will be altered in such a way that the fertilization, should it occur, will cause will necessarily cause the newly formed baby to die, right? That is not debated, right? The only thing that's debated is these procedures that they put in place and everything like that. All right. So the fact that the RCMP declined to investigate does not negate the existence of criminality. All right, it's very, very important here. This is important. It does not. She didn't get acquitted. Right? That's what I'm trying to say. There's no acquittal here. Okay, there's no acquittal. We can't investigate because of these nonsense reasons. A failure to investigate is not a finding of innocence, nor is it a determination on the merits. It is merely an institutional decision not to pursue the matter. Conflating non-investigation with non-criminality is a category error. History is replete with examples where grave crimes were ignored, minimalized, or procedurally buried while remaining crimes of substance. Absolutely. So there's all kinds of crimes that have never been, you know, investigated because of these, you know, procedural, you know, you know, see, the only reason that it's not being investigated is because of the procedure that they put in place, right? Um, Criminality exists independently of police willingness, political comfort, or administrative convenience. Absolutely. So at the core of this matter lies this deception. The woman was not informed of the true mechanisms of action of the drug prescribed to her. Absolutely, that is absolutely true. Not informed is a little bit generous, more like lied to by omission, right? Basically, she was affirmatively misled by being told that the implantation marks the beginning of pregnancy. Right? The implantation. Does the implantation mark the beginning of a pregnancy? Wait a minute. Let's go back to embryology, and we'll see that's nonsense. This is a claim that is scientifically and embryologically false. Deception vitiates consent, right? That's very, very important to remember here. Deception, right? If you deceive a woman to take these kinds of pills, there's clearly no consent, especially if she's like, not really able to understand, and especially if she's a minor. There's so many minor girls that are taking these birth control pills, and there's just no mental capacity to be able to understand that. Even if they were to really understand the whole thing, right? They're underage, right? They're literally like 15, 16, 17-year-old girls on these birth control pills, destroying their purity and all this stuff. It's grotesque. When consent is obtained through material misrepresentation, there is no consent at all. Then to then argue that evidence does not exist because the deceived person cannot later articulate the deception is illogical, right? Deceit, by its nature, conceals itself from its victim. Requiring the victim to independently discover the deception before harm occurs imposes an impossible evidentiary burden and functions as a built-in shield for wrongdoing. The harm in this case is not hypothetical. It is concrete and irreversible. A human life was created and subsequently destroyed as a direct and foreseeable result of the pharmacological intervention. My son paid the ultimate price. He cannot be expected to testify. Precisely, because he is deceased. He's dead. He died. The absence of testimony from the deceased is not evidence that no crime occurred. It is evidence of the gravity of the harm. Legal systems routinely recognize that homicide victims do not testify, and their silence does not operate as an evidentiary defect against justice. Likewise, the woman cannot reasonably be expected to testify against deception, against a deception that was successful at the time it was perpetrated, and continues to be successful. She continues to be deceived. Her inability or unwillingness to participate does not erase the deception, nor does it cleanse the conduct that followed from scrutiny. To treat her non-participation as justification for closing the file is to privilege procedural convenience over substantive justice. This complaint was not dismissed for lack of merit. It was dismissed, and she certainly was not acquitted. It was dismissed on procedural grounds. This distinction is critical and must be stressed. No adjudicative body ruled that the science was wrong, that the deception did not occur, or that the harm was unreal. The dismissal arose from procedural barriers. The absence of a recorded in-person statement, the refusal of a deceived party to participate, and institutional reluctance to pursue a politically sensitive issue. When procedure is elevated to such a degree that it prevents any examination of substance, the result is not neutrality, but injustice. Certainly injustice. What emerges from this ordeal is not a finding that no wrong occurred, but a system that's structurally, a system structurally disinclined to confront it. The law was not applied to the facts. The facts were avoided by the law, by the procedure. Why it's the law. I don't know if we get 15 minutes. I'll be right back.